Welcome to this training video on the core concepts in human rights, which will be delivered by THRE. My name is Suki, I'm Policy and Engagement Lead, and I'm going to be delivering this online training with my colleague Olivia.
Hi there, I'm Olivia, also a Development Officer at THRE.
Just a little bit of information about us if you haven't came across THRE before. THRE stands for Third Sector Human Rights and Equalities. We are a Scotland-wide project led by GCVS, that is Glasgow Council for the Voluntary Sector, in partnership with Highland TSI or HTSI up in the Highlands. And what we do is we produce free training and resources on how third sector organisations can apply a human rights and equalities first approach to your organisational development and delivery. We are funded by the Scottish Government's Equality and Human Rights Fund, managed by Inspiring Scotland. So the aims of this training course is really threefold. So first of all, to understand the legal frameworks that underpin human rights at the international, UK and Scottish levels. To understand what role the third sector plays in human rights practice in Scotland and the UK, and to finally understand how to build rights into your practice using a range of frameworks and practical examples. So we have got quite a lot of content to cover in order to achieve those aims, but I'll just walk you through what to expect throughout this series of learning videos. So we'll start off with a really basic question: what are human rights? Looking at the principles that underpin human rights, where they came from, and a bit of a timeline as to sort of how they've emerged over the last few decades. Then looking at how we have rights at an international level, taking a bit of focus at that sort of UN level in those international conventions before. We'll bring it home a little bit closer with rights in the UK and Scotland. What laws do we have in terms of the Human Rights Act and some other pieces of legislation? Then looking at what else is happening in terms of policy legislation and kind of beyond in terms of human rights work in Scotland. And then once we've got a good baseline understanding, we'll then take a look at how we can take that knowledge about human rights law and put it into practice with a bit of a focus on the role of the third sector in human rights. We've got a framework: fulfill, inform, advocate, and that'll hopefully make a bit more sense to you later on. And then finishing with some frameworks for action. So panel, triple AQ and FAIR. Again, that might not mean very much to you right now, but hopefully it should make sense to you later on in terms of practical ways that you can use human rights to support your work and communities that you work with and for. And then finishing with a bit of reflection.
So we're going to be doing a lot of talking about human rights over the course of this training, so it's probably useful to get some basic information down. So, what are human rights and where do they come from? Human rights are rights that are inherent to everyone, regardless of your identity or your background. They provide a minimum standard for how all people should be treated and are rooted in the recognition that we all share a common fundamental humanity. We have them simply because we are human. So our rights come from various legal frameworks. On the right hand side of the slide here, you'll see some examples of rights that we have through the Universal Declaration of Human Rights. Some of which might be familiar to you, some might be new to you. I won't read them all out, but some examples are the right to life, freedom from discrimination, and perhaps the freedom of religion and belief. Our human rights cover everything that we generally need to live, to have a decent life, and these legal frameworks exist in order for us to make sure that that becomes a reality for us. Over the next few slides, it's basically going to be a crash course on human rights law, but I'll keep it quite top level and take you from that international level down to the national and then bring it a little bit more into local context. So we're just going to talk through this timeline here. Don't get too intimidated by all the dates and the acronyms. The most important and relevant parts will be spoken about later on, but we just want to really set the scene and give some context for the history of human rights. Human rights as we know them today emerged in the aftermath of World War II, and they've evolved over the past 100 years through key milestones and international and national legislation. The end of World War II brought about a need to make sure that no more atrocities of its like could happen again, and this set the scene for the development of human rights as we know them today. So, in 1948, the Universal Declaration of Human Rights was then developed, and for the first time, human rights were to be universally protected. The Universal Declaration of Human Rights sets out general principles and created an agreement amongst UN states to support human rights. However, this was not legally binding. After this, in 1950, the Council of Europe and the 46 states that make up the Council decided that they wanted to take this further, and the European Convention on Human Rights came along. This became the first legally binding piece of human rights legislation and gave protections for human rights at a European level. The UN then decided to follow suit in 1956 in creating a more comprehensive and detailed piece of rights law, which came about in the form of the International Bill on Human Rights. This provides a basis for much human rights law throughout the world, and this bill includes two treaties that are split up into two categories, and they're called covenants. So we have the International Covenant on Civil and Political Rights, and then we have the International Covenant on Economic, Social and Cultural Rights. We'll be talking about these a little bit more later, but for now it's useful to note that there's a distinction between civil and political rights and economic and social and cultural ones. Since then, over the last few decades, there's been a range of additional treaties created, which we can refer to as group protection treaties, such as the Convention on the Rights of the Child and the rights of persons with disabilities. These group protection treaties acknowledge that some groups of people have additional barriers to accessing their human rights, and they have specific needs that need to be addressed. We'll learn a little bit more about those later on too. So, that's where human rights came from. But what do these laws contain? Human rights, as defined by the United Nations, are universal, inalienable, indivisible, interdependent, and interrelated. They are universal, meaning that we have them regardless of our background or our identity. They are inalienable, meaning that they can't be taken away from anyone. They are indivisible, meaning that all rights have the same level of importance and should be treated as such. And they are interdependent and interrelated, meaning that they link in with each other and support each other. One right not being met meaningfully could lead to other rights being impacted. So, of course, there are exceptions to this, and we'll all be aware of instances where people's rights have been restricted. So, for example, older people who are suffering from conditions like dementia or Alzheimer's, their right to liberty might be taken away if they're no longer able to make decisions for themselves in a safe way. This might result in a family member or a healthcare professional making decisions on their behalf. The caveat here is that any restrictions on this right must be proportionate, reasonable, and justified. So in this example, it would be best practice to regularly review decisions being made, review whether or not that person's capacity to make decisions has changed, and check what indicators there may be of what that person's wishes are, such as the power of attorney or previous care plans that they contributed to. Rights can also be seen as positive or negative. So negative rights essentially just means that it requires the state to not interfere with an individual. So thinking about things like the right to life or the right to privacy. These rights usually don't require much resources to fulfill. In contrast, positive rights require states to take action to ensure that the right is being met. This can be quite resource intensive. So some examples of this are the right to education or the right to social security. Generally speaking, negative rights tend to be given the most weight by states in comparison to positive rights. And unsurprisingly, this is because positive rights require more resource and budget for fulfillment. This will be something that we'll get into a little bit more later on with a kind of discussion around civil and political rights versus economic, social and cultural rights. But for now, it's just important to remember that there are such things as positive and negative rights.
So where do our human rights actually come from at an international level? So at an international level, human rights treaties are agreed upon and adopted by countries or states at the United Nations level. We'll go through specific treaties in a little bit, but this is some general information about what those legal frameworks or treaties look like. They are voluntarily signed up to, with the official phrase being called ratified or ratification. And once signed up to, the obligations within these treaties are legally binding for countries at a UN level. So they are held accountable by other countries in the UN system who have also signed up to these treaties. They have the responsibility to respect, protect, and fulfill the rights that are in these treaties. And progress is checked up on regularly, so it's not the case that you just sign up to your international obligations and that's it. Each treaty has a committee or a body that acts essentially as a watchdog that does regular reviews of each country's progress. This will generally involve the country sending the committee a report on what they've done to meet their obligations under international law, and civil society and third sector organisations from that country also get an opportunity to submit evidence to show how well or how badly a country is doing under the obligations. And this gets reviewed on a regular cycle every few years, and it's quite an active process. Again, we'll speak about this in a little bit more detail later on, but this is just a general overview of what that process looks like. So we previously spoke about the responsibilities that states have under human rights obligations. These were respect, protect, and fulfill. I'm just going to give you a little bit more detail about what those actually mean in practice. So first of all, respect. That means do not infringe on human rights, refrain from interfering with the enjoyment of rights. Simply put, don't get in the way. So as a government, don't do stuff that means that people can't access their basic rights. So for example, with the right to vote, an action that would be not respecting rights, that would be infringing on people's rights, would be shutting down hundreds of polling centres, meaning that people have to travel really far distances in order to be able to vote in person, or adding a fit charge in order to be able to vote. That would be not respecting human rights. That would be adding barriers to people being able to access their right to vote, for example. In terms of protecting, holding bad actors accountable, prevent others from interfering with the enjoyment of rights. So just because you're not doing anything wrong doesn't mean that that's your job done. You also have to make sure that other people are doing what they need to do in order to respect other people's rights. So an example of this would be taking action against companies that are polluting local rivers or dumping industrial waste into waterways and making water unsafe to drink. That would obviously be a infringement upon the right to clean water. So making sure that you're stopping these companies from doing that, making it illegal to do so, and making sure that they're held accountable when things like that happen, that is protecting rights. And then finally, fulfill. Adoption of policy and practices, adopt appropriate measures towards the full realisation of rights. So this means making sure that domestic law and practices are also in line with these international obligations. That's why we have things like the Equality Act, the Human Rights Act, and other pieces of domestic law and policies and practice that we'll talk a little bit more about later. But it means that you can't just do the bare minimum. It's about making sure that everything that you do internally is in line with these international obligations. So that's what these responsibilities are, and in the next slide we're going to have a little bit look about what rights do these treaties actually cover. So who is responsible for human rights? In the previous slide I mentioned the state as being who is responsible for making sure that human rights law is upheld. The state is not just the UK government, it's all parts of the public sector. So local authorities and councils are also part of the state, things like the police service, the military. Anyone who is part of the public sector is also what is known as a duty bearer under this international sort of law and international legislation. In terms of what responsibilities or duties actually look like in practice, there's a whole range of things that come with human rights that aren't just about ticking a box or filling in a form. So first of all, awareness raising and training. People can't understand or advocate for their rights if they don't know that they have them, and likely on the other side of things, people who are responsible for rights can't uphold them well if they don't know that that is their duty, that is their responsibility either. So awareness raising and training is a really key component in terms of building a human rights culture in which everyone is aware of what their role is and what needs to be done in order for human rights to be a realistic thing. Data gathering and reporting. It's really important for us to be able to understand the progress that's being made on rights, or even the lack of progress that's being made on rights, and a key part of that is being able to understand the figures, the statistics behind it. Related to that is monitoring and accountability, making sure that those who are responsible for upholding rights are regularly checking in, giving feedback, and giving updates on what is actually happening in that country in terms of human rights progression. Finally, setting budget with human rights in mind. A key thing that can often happen when it comes to human rights is there's just no money left over, but actually that's not something that should be happening, because budgets and policy decisions should be made with human rights in mind from the outset. This is a process known as human rights budgeting, and it does what it says on the tin. It is creating policy decisions and budgets with human rights centred at them from the very outset, so that you don't get in a situation where you're at the end and you go, oh, we've not got any money left over to make sure that people's human rights are being upheld by this whole process. So the main point I want to emphasise here is that human rights don't exist in some silo. They apply to all parts of the policy/decision-making process, and they link into all parts of government infrastructure, policy decisions, and everything that comes with making people's lives in Scotland and in the UK better, and closer to a decent standard of living.
So that was all the principles behind human rights, but what are they actually? What do rights cover? Here is where we get into all of that. So we're beginning at the international level. We'll begin with looking at the core treaties in the International Bill of Rights. So the rights that are in these treaties are peppered throughout much of human rights legislation that you will have come across or heard about. So as mentioned in the previous timeline, within the bill there are two covenants. One is called the International Covenant on Civil and Political Rights, and the other is an International Covenant on the Economic, Social and Cultural Rights. So the articles in these covenants tend to be what comes to mind when we think about human rights. For example, the right to life, the right to vote, the right to social security, the right to health, or perhaps the right to food. Civil and political rights are rights that are all about ensuring an individual's ability to be part of a civil and political life without discrimination or repression. Civil and political rights tend to be what we call negative rights, meaning that in order to fulfill these rights, governments need to not interfere with them. So, i.e. not shutting down peaceful protest or only using your private information when absolutely necessary. Some examples of this kind of right would be the right to a fair trial, the right to vote, or the right to privacy. The ICCPR rights are usually the ones that we're more familiar with in the UK, as they make up more of our domestic laws. Rights in the International Covenant on Economic, Social and Cultural Rights are often less recognised, and that's partially because of how they can be seen to be more resource intensive to fulfil. But they are just as important for us to achieve a decent standard of living. And these rights impact on many of the key issues that we are working on in the third sector, so that's why it's so important that we chat about them a little bit today. The rights that come under this covenant are the right to work, the right to social security, the right to an adequate standard of living, the right to education, the right to health, both physical and mental, and the right to a cultural life. This slide is all about the kind of parameters of fulfilling economic, social and cultural rights. So it's not just about tick boxing, have we got this right, yes or no. There are a whole range of parameters around this. So we took the space to really think about this because it's useful for us as third sector organisations to really understand the processes behind rights being met or not met meaningfully. We want to establish that reaching our human rights is not a start-stop or a yes-no process, but it actually ends up being more of a continuous upward journey towards realisation. Speaking of realisation, that brings us to the first concept of progressive realisation. So this is the obligation that states have to gradually work towards the full realisation of human rights, but in accordance with the resources that they have available. So they must prove that they are actively trying to progress with these rights as much as is reasonable. States kind of have a duty to use their maximum available resources for this progressive realisation. Even states that are not in financially strong positions, they can start thinking about how low or no budget interventions could be put into place to really ensure that progress is being made towards those human rights. But that doesn't mean that countries with lower resources get away with ignoring these rights altogether. Economic, social, cultural rights require something called minimum core obligations to be met. So this means that while you could be working towards these rights, there is a certain threshold that must be met that ensures the minimal essentials of each of these rights. So our next concept on screen is the concept of non-regression. The prohibition of non-regression means that in the pursuit of fulfilling these rights, you can't reverse the progress that you've made towards the current enjoyment of rights. For example, states must ensure that their new policies and measures don't undermine, for example, maybe the right to healthcare or right to social security benefits. There is an obligation for states to maintain that existing level of protection. And our final concept on screen here is non-discrimination, which is core to much human rights legislation, and ESCR is no exception. So there must be specific measures put into place to ensure the protection of rights of marginalised populations as a priority. So even when resources are limited, the state has a duty to adopt measures to protect those that are most at risk. Group protection treaties are treaties that aim to ensure that the rights of vulnerable people are upheld, recognising that it can be more difficult for some groups than others to have those rights upheld. On the slide here, you'll see the group protection treaties that the UK has signed up to. These additional pieces of legislation don't necessarily create new rights, but they actually supplement the existing ICCPR and ISASCR rights in that they recognise that for certain groups they will have a harder time accessing their rights, and therefore they do need additional support to achieve the same rights as others. The Convention on the Elimination of All Forms of Discrimination Against Women, for example, this supplements the existing right to work by recognising that access to work for women ultimately involves things like maternity leave, protection from sexual discrimination, protection from sexual harassment in the workplace, and equal pay for equal work. This can also be seen in the UNCRC, so that includes the right to play, acknowledging that for children, a key part of the development of a good standard of living means a decent amount of play. So it's important to recognise as well that there are many groups that aren't specifically protected by UN conventions, such as LGBTQ+ people. However, there are discussions on how to better protect these groups. So, for example, there is a treaty on the rights of older people that is currently in development. While rights can sometimes seem like a static framework, they can and should adapt to the emerging issues around us. So, for example, the right to a healthy environment was adopted by the UN General Assembly in 2022, and this recognises the importance of responding to the evolving climate emergency. This right aims to protect people from the effects of climate change, and in particular from the effects that prevent them from living a dignified life, acknowledging that environmental damage does have negative implications for the enjoyment of all human rights. This right is not set out in a legally binding international treaty, but it is increasingly recognised as a human right. The UN Special Rapporteur describes the healthy environment as one that meets these 6 criteria, and that is clean air, safe and sufficient water, healthy and sustainably produced food, a safe climate, healthy ecosystems and biodiversity, and toxic-free environments where people can live, work, study and play. In order for a healthy environment to be achievable as a human right, there are also 3 key elements to the right that states must uphold. These are known as procedural parts of the right to healthy environment. So that includes access to information. So that means that governments must make available information for people to support decisions on environmental issues and to monitor progress on climate change indicators. And then the next one we have here is public participation. So decision making about environmental issues should include those that are impacted by such issues. Communities who are most impacted should be prioritised and barriers to participation should be addressed. And the final procedural right here is access to justice and effective remedies. So this means that there must be clear ways for citizens to take action and to seek accountability if the right to a healthy environment has not been upheld as a result of an action or a policy. Resources should be made available to ensure that justice is accessible, such as funds for those that are low income, materials in other languages, and clear signposting for support services. Climate change can seem like a really large and nebulous issue, but the right to a healthy environment really sets out a clear pathway towards climate justice. Okay, so that was a lot of information that we've just thrown at you, and we don't want it to all get lost, so we thought it'd be good to just have a little bit of a summary of this past section, which has been rights at an international level. So first we've got that rights are universal, inalienable, indivisible, interdependent and interrelated. We've also got that our rights come from a range of international treaties and that states have that obligation to respect, protect and fulfil our rights under these treaties. And there's also that concept that our rights are split up into 2 covenants, which one covers civil and political rights and then one covers economic social and cultural rights. And then there's also the concept that we know that some groups have more barriers to accessing their human rights than others, so they have additional protections that we call group protection treaties. And finally, here we've got that rights aren't a yes, no, or a tick box, but it's about doing the best with what you have, always moving forward and making sure that there's just that minimum standard that is being maintained while you keep reaching for more.
So Olivia has just taken us through the basics of human rights, the international system, and a lot of the key treaties that we need to know about. Let's bring it down to a more local level by thinking about rights in the UK and Scotland. So in order to talk about rights at a UK and Scottish level, we need to get to grips first with the concept of incorporation, because these pieces of legislation that we have in the UK and Scotland came into being through incorporation. So incorporation is the act of taking legislation that exists at an international or regional level and bringing it into domestic law. So incorporation of the European Convention on Human Rights gave us the Human Rights Act, and the incorporation of the UNCRC gave us the UNCRC Scotland Act. It makes what previously was a much more conceptual, piece of international law much more real by bringing it into a domestic context. So why incorporation? What is so special about it? So incorporation is important for a number of reasons, many of which we put on screen here. I'm just going to go through them one by one. So first of all, routes to justice and accountability. Let's take, for example, the UN Convention on the Rights of the Child. This is an international convention, which means that the solutions, the routes to justice and accountability, without incorporation, they're at an international level. It's a big ask to ask a child or young person if they've got an issue with something that's not quite right with their education, their healthcare, or anything else that they need to make have a decent standard of living, for them to take a case to international court in Geneva or Strasbourg. That is a really big ask. Any sort of judicial process is a big ask, but typically under international law, the solutions are also international. That's why incorporation is really important, because it means bringing those solutions to justice and accountability into a much more reachable national or domestic level. So having the UNCRC and Scots law now means that children and young people can take cases to local Scottish courts in Glasgow and Edinburgh and Dundee, wherever they are, instead of having to figure out how to contact an international organisation to have their rights met. Rights are now the responsibility of their local police officers, their local teachers, and local courts and judges in those courts. And that makes justice and accountability much more accessible than it previously was. Next one, funding, budgeting, and resourcing. The way that we've typically spoken about human rights can often mean that they're an afterthought in a lot of instances, particularly around budgets and budget setting. By having rights in our national law, it makes them much more closer to the forefront of our thinking, and this can mean prioritising human rights when we are setting out budgets and making sure that we've got the adequate amount of resources available for those rights to be upheld. Next reason, building human rights into our cultural and social context. So again, we have a lot of rights in international law, but that can often just seem quite far away and not necessarily something that is relevant to our everyday lives. Bringing rights into Scots laws mean that we can put them into a Scottish context and understand how they interact with all the other bits of law that we have and the specific institutions that we have in the UK and Scotland that need to be held accountable as rights holders. So, ever since we have again brought the UNCRC into Scots law, lots of different resources and bits of training have came out that talk about how UNCRC is relevant in NHS settings, in Scottish school settings, and how different people that are responsible for making sure that children's rights are met can take action to make sure that they are doing what they can to uphold children's rights. By having that push from incorporation, we now have a lot more information on what the UNCRC actually means in a Scottish setting, and that's what that point is talking about when it says the cultural and social context. We've been able to localise rights and make it something that feels Scottish, that feels like a part of our everyday, rather than something that's a bit more nebulous, a bit more far away, and a bit more vague. Fourth, keeping track of standards and outcomes internationally, nationally, and locally. So this just means that we are now part of a number of countries across the world that have incorporated rights into our domestic frameworks. That means that we have a range of other, I guess, standards to kind of hold ourselves up against. So that means that we have now got clear monitoring and evaluation standards because we had to write them out into a piece of legislation, and that allows us to keep better track of the progress that we're making across Scotland to ensure that no child in any part of Scotland is overlooked or worse off when it comes to rights. Fifthly, a model of progress and good good practice for rights. Human rights successes in Scotland aren't just a win for Scotland. Being able to demonstrate rights and actions, being able to have demonstrable case studies for how we've been able to make sure that rights are achievable is not just a win for us, but actually will allow other people across the world and other countries across the world to use the examples that we have set out to make the case for human rights for their own people, their own places, and their own purposes. Finally, a foundation to build from. So incorporation is by no means the end of the game. Human rights are a floor. They should be a bare minimum for how we expect to be treated by those with power, and absolutely not a ceiling to aspire to. So actually bringing rights into Scots law and setting expectations that our human rights are a basic duty and responsibility, we can change attitudes and expectations in that human rights aren't just an extra, they're not a fun add-on, but actually the place that we need to begin building from. So for rights holders, incorporation can also then empower them to expect better from our institutions and public bodies and give people a stronger voice with legal backing when speaking up against injustice or mistreatment. So that's a few reasons why incorporation is important, but most crucially it is about bringing that sort of faraway ideal of human rights that doesn't quite always feel like it has an impact on our daily lives and brings it much closer to home. It gives us solutions in our local institutions and makes sure that we can speak about them in a way that is relevant to our own laws, our own institutions, and the key sort of issues that are facing us in a local context. So the first piece of legislation we're going to look at is the Human Rights Act, and this incorporated the European Convention of Human Rights into UK law, and these are what we generally know as our civil and political rights. And so I'm going to give just a few examples of how incorporation via the Human Rights Act brought real action or justice in a few examples and the rights that these relied on. I'm just going to bring them up on screen and then we'll talk through them. So the first one is the Hillsborough disaster. The Human Rights Act via the right to life allowed for victims of the Hillsborough disaster, in terms of the survivors as well as the families of victims themselves, they were able to use the right to life in the Human Rights Act to call for the disaster to be reinvestigated and for new verdicts to be found against the police and sort of other emergency services that responded to the event, and allowed for, I guess, some sort of justice to be found for the survivors and the victims of that disaster. Secondly, allowed for action to be taken for those dismissed from military service for being openly LGBTQ. This relied on the right to freedom from discrimination. So some officers or those that were serving in the military, if it was found that they were gay or bisexual or anything other than heterosexual, they were unfairly dismissed from service. And up until the point of the Human Rights Act being brought into UK law, there was not any sort of easy recourse for these individuals, but the right to freedom from discrimination allowed for these individuals to be recognised for their military service and for some compensation to be given to them. Thirdly, it led to modern day slavery becoming a criminal offence. So this relied again on the right within the Human Rights Act to freedom from slavery. So this was quite surprising to us when we were researching this, but actually previous to 2015 there was actually no specific modern day slavery legislation, and so without the Human Rights Act being a part of UK law, there was a few cases in which individuals would not have actually been able to find justice or any sort of criminal conviction for the people that were holding them captive. And these are really core examples of very different cases, but underpinning all of these is the Human Rights Act in terms of how individuals in each of these cases were able to find justice and find accountability. Now, without the Human Rights Act, yes, they would have had these rights, but they would have had these rights at an international level through the International Convention on Civil and Political Rights, but because that convention exists at an international level, they would have really struggled to find justice as they did in these instances with the Human Rights Act. Another set of rights that have been incorporated into Scottish law specifically is in the form of the United Nations Convention on the Rights of the Child. This is given as the UNCRC Scotland Act. This one only came into force last year in 2025, so it is still emerging. It's something that we're still finding kind of how it lands in courts. And so I've only got 2 case studies here for this one, but I think they're good examples that still demonstrate the power of having incorporation even at this early stage. So the first one is on how it led to reform of policies on the use of restraint in children's mental health care facilities. So this was a case that was brought forward by the Children and Young People's Commissioner along with organisations like the Scottish Human Rights Commission. They were urging the Scottish Government to improve policies around restraint in mental health care settings. They had carried out freedom of information requests to find out what policies health boards had on restraint, and basically found out that these policies were really inadequate and didn't even reference children's rights in any form. And as such, they took this to the Scottish Government and basically said that, you know, they could use their powers under the UNCRC to raise a judicial review. As a result of this, Scottish Government confirmed that they're going to be revising the statutory code of practice to make it rights-based and to review how they are, you know, using restraint in seclusion settings and making sure that there's mandatory recording and reporting around these uses of restraint in these settings. So this is a little bit convoluted, but it's still a really good example of how organisations have been able to use the UNCRC to make change for children and young people. In this example, trying to make sure that when restraint is used for in settings like mental health care settings, it's used in a way that is framed around their rights and is not just arbitrary. The second one is a judgment that was taken just a few weeks ago, and it is focused around the voice of children and young people and also about their best interests. So part of the UNCRC says that children have the right to be heard in all decisions that impact them, and also that their best interests should be considered as well in decisions that are made. And this recent case focused on a pair of siblings, an older brother and a younger sister, and they had been separated in care. And decisions around the young girl in care were made so that actually her older brother was restricted and not able to see her as often as he would like. All of this decision making was done without the older brother. He was not able to have any say in any of this. And he basically argued that because he is still a child under the UNCRC, he's under the age of 18, actually for him to have been completely disregarded in these decisions around the young girl's care and how often she was able to see her brother, that was actually a violation of the UNCRC because his best interests and his right to be heard was disregarded. He was actually successful in this case, and so the children's hearings system is now, I think, going back on their decision. They're going to review that decision and make sure that they're taking the voice and the decision of the older brother in that process because he is also a child under the UNCRC. So those are just 2 examples of sort of legal impacts that the UNCRC has had so far, but hopefully there are going to be many more examples to come in the future. There are lots of organisations that are reporting on this or keeping an eye on this, and we'll link to those at the end of this training, and you'll find further resources where we can give you access to organisations like Together, the Scottish Alliance for Children's Rights, who write about the UNCRC and update people on kind of case studies and kind of emerging practice as well. So that is what we've got in law in terms of human rights law, but that's not to say that that is all there is. There's a lot of work that's happening around human rights in Scotland, not least at a sort of civil society, third sector level. There's constant campaigning and advocacy that's happening on rights, but even at a sort of government and local authority level, there's also lots of stuff to note when it comes to human rights. So I'm just going to briefly take you through a few key highlights. There's much more of this out there, but I'm just going to stick to sort of like four key examples. So the first one is SNAP2. That is an acronym. SNAP stands for the Scottish National Action Plan for Human Rights, and it's SNAP2 because we're on our second edition of this. This is a vision for Scotland where everyone lives with dignity, and it is a coordinated bit of human rights activity between public bodies, civil society, and rights holders, and it aims to promote greater awareness of human rights to advance the realisation of them. They list basically under this plan 54 actions that should be completed within the time frame of 2023 to 2030 in order to improve human rights in Scotland. And we'll link to this so that you can have a look at it, but it's quite interesting, and you'll probably see yourself and maybe your work within some of these actions. Secondly, the Equality and Human Rights Mainstreaming Strategy, Action Plan and Toolkit. This is from Scottish Government, and it is a piece of work that's happening in which they're trying to mainstream equality and human rights across the public sector, across Scottish Government. And I would actually highlight the fact that the toolkit's a really useful resource. So what it does is it sets out a survey that you can do to basically assess yourself in terms of where your organisation is in its equality and human rights journey. How much capacity building do you need? Where's the leadership? Is there some strategic thinking that you need to do? And it recommends resources that you can then look at in order to support your work and continue that progress. Even if you're not a public sector organisation, I'd still recommend having a look at it. I think it's actually a really good set of resources, and it collates a lot of stuff from across the sector, and it helps really to help you skip that bit of searching and sort of pulling together of all these resources because it's already here in one handy place. The third thing that I'd like to highlight is the Scottish Human Rights Tracker. So we'd mentioned earlier that all of the international treaties that we've signed up to, they are regularly reviewed. They have these committees that basically are watchdogs that review each country's progress. And when they do that, what they do is publish a set of recommendations that say, these are what you need to do in order to do better. These are things that you need to improve on, and we've set out how we think you should do those. These are called concluding observations, and you can find them for each human rights treaty. So the economic and social cultural rights, there'll be a whole list of actions that the committee has recommended that the UK should take forward. The committee on eradicating racial discrimination, they'll have done the exact same. So there's all these recommendations out there that basically can provide a really good roadmap for how we can level up in terms of our human rights practice. But like I said, there's quite a lot, and it's all kind of scattered. So what Scottish Government have done is they've pulled them all together into this human rights tracker, one place, one website. So we can have a look at it later on in this training, but I'd just like to highlight now that actually, yeah, you can just go on this website and find a really easy sort of one place where you can look up actions in relation to, let's say, disability, or let's say ethnic minority rights, or children and young people, and you can see what's happening, what the progress is, and also use that to hold government to account and go, what actions have you taken under X, Y, and Z action, or where have you been allocating your budget and your resources in relation to this. So it's a good handy tool for just getting up to speed on the Scotland's human rights record and what we're doing to kind of move forward. And then lastly, I've got a proposal for a Scottish Human Rights Bill. So this is, again, in relation to incorporation. The Scottish Human Rights Bill is a proposed bill that would involve incorporating the Convention on Economic, Social and Cultural Rights, the right to a healthy environment, and all those group treaties that we mentioned earlier in this video. This is a proposal that's been in development for a number of years, and the current government have said that they would like to keep going with it if they are re-elected. So this might age this video a little bit, but basically we need to wait and see after the Scottish Government elections what will happen with the Human Rights Bill. But Overall, though, it further demonstrates why it's important to learn about international legislation that exists, as it may end up being something that is a lot closer to home in the future. So that brings us to the end of part 1 of this training. Just as a reminder, we have covered the basic principles of human rights, rights at an international level, looking at incorporation, rights in the UK and Scotland. I think that is probably enough for one video, but there's much more to come, so you can expect in the next portion of this that we're going to be looking at the role of the third sector in human rights, as well as ways in which you can actually take all of this knowledge and apply it to your work through a range of practical frameworks. So please do continue watching, and we hope this video has been useful for you. Thank you.